Hey, Chrissy, I've been a lawyer for, 33 years now, and I've certainly over the years read about this often enough, but for the first time, a case like this has walked through my door, and that is this. The people came and approached me. It was a daughter, and she said, Tom, Dad had a will where he left everything to his nephew. He's right here in Central Florida, left everything to his nephew. Well, guess what? The nephew murdered his uncle.
Oh, my gosh.
Yeah. And so I knew this, that, Florida law is like a lot of other states now, that if you murder somebody, you are no longer included in their will. It is though you have predeceased them. And these new laws they're relatively new because it happened because of the case in Texas where the twins, maybe Mendez were their last names.
Correct.
They murdered their parents. Texas did not have such a law. And even though they murdered their parents, they inherited all their wealth. So a lot of the states are very quick to jump on this, which is the rightful thing. And so you and I were looking at a statute this morning, and it says, hey, if you have intentionally killed somebody or participated in the killing of somebody, you are no longer in their will as if you have predeceased that person.
And so it's interesting, Tom, because this is something that has been around for quite some time with insurance policies, as we know.
Mm-hmm.
So it's interesting that now this is, of course, again, so there could have been an insurance policy. Of course, the policy wouldn't pay out, but in a will, anything else that is not subject to an insurance policy or something like that would be paid.
So it was a daughter that ended up calling me. She's up in New York, and she told me, Tom, I said, first thing I said, I want to see a copy of the will. I want to know what's going on. She says, well, the detective with Orange County Sheriff has it. It's evidence. They're going to use it as evidence. But the sheriff ended up scanning a copy and mailing it to me. And what was interesting about this will is that this man, he left everything to his nephew. He did not have a backup. There's no alternate. Whenever we do wills, we always have plan B, right?
Absolutely.
And so what happens then is that the Florida statutes would write a will for him, and now it says everything is going to the daughter. And, of course, it's the daughter who's now calling me about handling this. So we more than likely will do the probate for him, and more than likely it would all go to the daughter, but we will have to prove to the probate judge that this nephew did kill his uncle. And I don't think that's going to be hard. I've just never done it before.
Well, that will be interesting because it will require a different type of proceeding. Because aren't I correct that too, what the statute is saying as well is it has to show that this person did in fact kill them. Mm-hmm. So either, like you said, some evidence, or obviously down the road it would be if there's a conviction on this person. Of course, that would be easy. Yeah. But prior to that.
So sad circumstances, but it will make a fascinating case for us.
Absolutely.
Hey, folks, my name is Tom Olsen. The name of the show is Olsen on Law. We thank you so much for all your great calls and questions. We do so much appreciate it. If I may, a suggestion for you, go outdoors and take pleasure in the beauty of nature. And as always, enjoy your friends and family. My name is Tom Olsen. You're listening to News 96.5.